We are now in Lecture 2, Part 7 on Ingram's Law. Here we're going to start with the US's worry about judicial tyranny, unlike democratic tyranny, at which we looked in the previous lecture. We're going to look at Eli's compromise that recognizes the necessity of strong judiciary as well as tries to limit it so that there isn't really that problem of the excess of the judiciary. And we're going to treat Eli's compromise as a version of formalist proceduralism. In the US, the worry is about the judges exercising too much judgment in their interpretation of laws. Recognizing the inevitability and the need for the judge's judgments and correctives, a legal scholar, Eli, proposed that the Supreme Court's activism should be limited to protecting rights of individuals only, as opposed to any kind of assistance to help to the individuals. Right? So here the thought is that Supreme Court should limit its activism to protecting rights of individuals only. More than that, protection of rights of individuals should be limited to protection of their participation in the democratic process, especially for the minorities. So it's really the participation rights that are the focus here. The idea is that if individuals are not prevented from participation in the democratic process, they can vote in whatever other protections or enhancements of the individual rights that ought to be through a democratic process rather than a judiciary process. This way, the judges do not have to take and exercise a position on what values actually express freedom or anything else in the moral core of the law. The prime example of the alien approach is judges putting a stop to redrawing boundaries of electorate districts to weaken the influence in the democratic process by the ethnic and racial minorities in the US. It's the sort of a thing that's been called gerrymandering. Alien approach is proceduralist and formalist rather than substantive. There are no substantive values as such upheld, other than the value of participating in the process in which the values are collectively determined. What might be a substantive value? Maybe something like access to medical care, right? The thought here is that it is not up to the judges to interpret respect for freedom that way, though it may be the sort of a thing that's voted in by the democratic process. The key here is just to make sure that everyone participates in the democratic process. So in this sense, the proceduralism here is formalist rather than substantive. There are no substantive values upheld. Substantive values are left up to people to vote, to be voted in. This approach is also backward looking. It is not attempting to introduce any new and updated meanings of freedom, but upholds the foundational constitutional value of equal participation of all in the democratic process. Ingram criticizes the alien approach for precisely this. It does not contribute to the progress of interpretation and clarification of meaning of freedom according to the changing and evolving historical circumstances. That Dworkin thinks is the essence of the judicial process.